Hey everyone, and welcome. So, if you're a first-year law student, let's be honest. Contracts can feel like this maze of old dusty rules, right? But really, when you boil it all down, it's about one single question. Which promises do we, as a society, think are actually important enough to legally enforce? Today, we're going to unpack the key ideas that take a simple promise and give it the full force of the law.
All right, let's just jump right in with the most fundamental question there is. Is every promise legally binding? I mean, if I say, hey, I'll give you my car next week, is that it? Can you sue me if I don't? Well, the short answer is nope. And that simple no is the entire reason we have this massive body of law. It's all about creating a system to tell the difference between a casual promise you might make to a friend and a serious, rock-solid commitment that a court will actually back up.
So, here's the game plan. First, we're tackling the absolute cornerstone, consideration. Then we'll get into what happens when a promise isn't really a promise at all. We're talking about illusory promises. From there, we'll see what it takes to change a deal that's already in motion, which will bring us to the infamous pre-existing duty rule. And finally, we'll tie it all together with the one unspoken rule that governs everything: good faith. Ready? Let's do it.
First stop, and it's a big one, consideration. Seriously, this is the magic ingredient. It's what separates a real, enforceable contract from what is basically just a promise to give a gift. You know, without consideration, all you've got is a nice thought. And, well, the courts really aren't interested in enforcing nice thoughts. Okay, so what is this thing? Think of it this way. Consideration is the price of the promise. It's the what's in it for me part of the deal. The law is looking for a bargain, a genuine exchange. You give something, I give something. It's this mutual give and take that tells a judge, hey, these people were serious. This wasn't just talk, this was a deal. And this is where things get a little weird, a little counterintuitive. You might be asking, okay, but does the exchange have to be fair? Like, could I sell you my brand new car for $1? And the answer, which blows a lot of people's minds, is, yep, absolutely. Courts will not get into the business of deciding if you made a good deal. All they care about is whether you made a deal. This is what lawyers call the peppercorn theory. The idea is that even something as small as a single peppercorn can be enough consideration because the court doesn't weigh the value, it just looks for its existence. A perfect example of this in action is the old school case Hamer v. Sidway. So you've got this uncle who tells his nephew, look kid, if you stay away from drinking, smoking, and gambling until you're 21, I'll give you $5,000. The nephew does it, but when he turns 21, the uncle's estate refuses to pay up. Their argument? The nephew didn't give anything. He just didn't do stuff. But the court said, whoa, hold on. By not doing those things, the nephew gave up something he had a legal right to do. That act of giving up a legal right, that forbearance, was his side of the bargain. That was his consideration, and it made the uncle's promise totally enforceable. Okay, so we've got a handle on consideration, but what happens when something looks like a promise, but it's kind of hollow? It's like a mirage in the desert. You see it, but when you get there, there's nothing there. In contract law, we call these illusory promises. So what makes a promise illusory? It's when one person isn't actually committing to anything at all. The classic example is saying something like, I'll buy your book for $10 if I feel like it. See? That if I feel like it part means I have total freedom to back out for no reason. I haven't actually promised to do a thing. So since my promise is empty, I haven't given any consideration, and that means we don't have a contract. The whole thing just falls apart. But here's a twist. Courts don't always like to let deals fail, especially in business. Take the super famous case Wood versus Lucy Lady Duff Gordon. Lucy, a big shot fashion designer, gives this guy Wood the exclusive right to market her brand. Later, she goes behind his back and makes her own deals. When he sues, she says, hey, our contract was invalid. You never actually promised to do anything for me. And technically, looking at the written words, she was right. But the famous judge on the case, Benjamin Cardozo, said, hold on a second. He basically argued that the only way this exclusive deal makes any sense is if Wood was implicitly promising to use his best efforts to sell her stuff. So the court wrote in that implied promise themselves, and boom, just like that, there was consideration and the contract was saved. Okay, so we've covered how to make a contract, but what happens next? What if you're already in the middle of a deal and somebody wants to change it? Hey, can we adjust the price, or I need more time? Well, this is where contract law can get really, really messy. And when it comes to changing a deal, the biggest roadblock you'll hit, at least under traditional common law, is something called the pre-existing duty rule. Now, why does this rule even exist?
It's basically to stop what's known as the hold-up game. You know, where one party gets the other over a barrel and tries to force them to agree to new terms they wouldn't have otherwise. The rule itself sounds simple enough. You can't offer something you're already obligated to do as new consideration. Let's say you hire a contractor to build a deck for $5,000 to be done by Friday. On Thursday, she comes to you and says, "I'm not going to finish unless you pay me an extra $1,000. You agree because you have a party planned. Well, that promise to pay the extra $1,000 is unenforceable. Why? Because she was already legally bound to finish the deck by Friday for the original price. She didn't offer anything new for that extra cash. It's a one-way street, and the law generally says no to that. The classic textbook case for this is Alaska Packers Association. It's a wild story. You have these fishermen who sign on for a fishing season in Alaska for a certain wage. But once they get all the way up there, in the middle of nowhere, they put down their nets and say, "We're not working unless you double our pay." The company is stuck. It's either agree or lose the entire season's catch, which would be financial disaster. So they agree. But when everyone gets back to port, the company says, "Yeah, we're not paying you that bonus." And the court completely backed them up. It ruled that the fishermen already had a duty to work for the original salary. The new deal wasn't a real negotiation. It was basically extortion. Now, this is super important, especially for your exams. That strict pre-existing duty rule, that's the old school common law rule. It applies to things like services or real estate. But for contracts involving the sale of goods, think cars, computers, anything movable, we have a more modern set of rules called the Uniform Commercial Code, or the UCC. And the UCC basically throws the pre-existing duty rule right out the window. Under the UCC, you can modify a contract without any new consideration. The only thing the court will ask is, was the change made in good faith? And that's a perfect segue to our last topic. So that brings us to our final piece of the puzzle. And honestly, it might be the most important one of all. It's this idea that's sort of floating in the background of every single contract ever made. It's an unspoken rule, an implied duty that's there whether the parties wrote it down or not. And that is the duty of good faith. Officially, it's called the Implied Covenant of Good Faith and Fair Dealing. And what it means is that the law basically inserts a promise into every contract that says, hey, you two are going to play fair with each other. You can't just stick to the literal black and white text of the agreement while finding sneaky ways to screw over the other person. You can't undermine the whole point of the deal. It's really the law's way of being the referee and making sure everyone acts with basic honesty and fairness.
So what does it mean to act in bad faith? Well, it can look like a lot of things. It could mean just slacking off and not even trying to do what you promised. Think back to that Wood versus Lucy case, if Wood had just sat on his hands and done nothing. Or it could be more direct, like actively getting in the other person's ways so they can't perform their side of the deal. Or maybe it's abusing some power the contract gives you. Basically, any of these things are a violation of that invisible handshake, that promise to deal fairly with each other.
And that really brings us full circle. I mean, we've been talking about all these foundational rules. Some of them are more than 100 years old. They were created for a world of handshakes and written letters. So the final question I want to leave you with is this. How do these fundamental ideas of a fair bargain and good faith even apply today? In an age where we agree to pages and pages of terms and conditions with a single click on a website. Think about that, because that's a question that the courts and you, as future lawyers, are going to be dealing with for a long, long time. Thanks so much for watching.